we're going to have invocation by Commissioner High. Anyone's willing to participate?
Thank you, Father, for bringing us here today, and thank you for this beautiful building. We pray, Father, that our minds would be on justice and mercy, and that we would do and think your will today. In Jesus' name we pray. Amen.
Amen. All right, roll call. Franny.
Commissioner Shajit Rakshram,
Present.
Commissioner Lori High,
Present.
Commissioner Nora Castaneda. Almost. Dr. Gary Wesson,
Present.
Dr. Ray Callis,
Present.
Vice Chair Tom Butler,
Present.
Chairman Rick Figueroa.
Present. All right, we have a quorum. All right, ladies and gentlemen, welcome to the building. Great to have everybody here. Good to see you guys. If I can see you guys, you're a little far away, but
Chairman,
yes.
sorry, Doug Jennings, General Counsel. We need to do another check on Commissioner Castaneda, please.
Okay.
Castaneda, Commissioner Castaneda, can you hear us? Commissioner Castaneda, can you hear us?
Okay.
All right, we've got to note Commissioner Castaneda absent currently.
Right, that's fine. That's
So I'll
fine.
note that.
We'll
Thank you.
or,
Sure.
if you want to
Sure.
text with her, let me know when she comes back on.
Chair, a question.
Yes.
Council, I think the statute requires a physical presence right there, and I think I do see her right there, so.
It requires her to be both visible and audible,
Okay, thank
and
you.
so she is not currently audible.
Okay.
Thank you.
All right. We'll walk ourselves through it. All right. Great to see everybody. Commissioners, we're gonna go with item C, public comment. Carson, we have none?
No public comments.
Okay. All right. Well, there you go. All right. Well, then we're gonna jump right in. So hold on, tell her just to hold on because we're gonna go to executive session. We'll go into executive session and consult with our attorney under section 551.071, subsection 1, 551.071, subsection 2, and 551.074 of the government code. The time is 8:40. After the executive session, we'll take a break and come back here. And I want to say 40 minutes. Is that what you're thinking?
Yes, sir.
So we're gonna go back here at 9:20 and pick up with any action items and executive session that we have from there. Okay? Now we're going to a room.
Yep.
Okay.
Chairman, will we be sent another link?
Yes, you will. Well, yeah, you're not. It'll keep that. They're going to transfer you. So stand by.
Okay. Yes, sir. Thank you. Thank you.
Hello?
Stay with us.
Can you hear me? Hey.
Yes.
Yes,
Okay,
I can.
Perfect. Okay, we're all up and running now. Thank you.
Am I up and running as well?
sure are. They will be in here for executive session shortly.
And are they calling this in or
They'll
we're
join this
already?
meeting.
Okay.
You're good.
Okay, thank you.
Thank you.
Commissioner Droxram,
Present.
Commissioner High,
Present.
Commissioner Castaneda, Dr. Gary Wesson. Up, Commissioner Castaneda, I'm sorry, I didn't hear you.
Chairman, if y'all are talking, we can't hear you.
You can't hear us, Dr. Callis?
I'm present.
We can hear her.
And we lost her video feed.
Callis, can you hear us? Castaneda, can you hear us?
Yes.
Okay. Callis, can
Dr.
you-
Callis? Dr. Wesson?
I'm here.
Dr.
Gary,
Callis?
can you hear them?
Yeah, everybody can
Yes,
hear
I
us.
can hear 'em.
I can't hear 'em.
Can y'all hear me?
Yes, we got you, Dr. Wesson. So Dr. Callis can't hear us,
Gary,
hear
can you
him.
hear me?
Yeah, I can hear him.
but we can't hear him.
Okay.
Or he can't hear us. I'm sorry. He can't hear us. Can you hear us, Doc?
I can hear y'all now. I can hear y'all now.
All right. So
Okay,
yeah, we're
Dr.
good.
Callis?
real quick,
Yes.
Dr. Callis, Dr. Wesson, and Commissioner Castaneda, you can hear us, right?
Yes.
Okay, good.
All right, Vice Chair Butler,
Up here.
and Chairman Figueroa.
Here. All right. I never know roll call was such an effort. Good Lord. I'm going to go back to open comments. I'm recognized Vice Chair Butler.
Thank you so much, Mr. Chair. Taking into consideration the calendar and the day, today being Ash Wednesday, the beginning of Lent, I would ask that, as we go about today's meeting, let's be reminded of, that we're all here for the right reasons, and be considerate of those that we know very little about sometimes, and the struggles that they're going through. We're all going through our own struggles, and so just kind of approach today in this meeting with that frame of reference, if you would, please. We're all trying to do our best, and we're all just trying to make it through the day and leave this state a little better than we found it. And so, in this political season, let's just kind of remember that, okay? Having said that, I appreciate, Mr. Chair, your indulgence and letting me make that comment. I would like to ask our executive director a question real quick, if I may, though. We received a lot of comments today in our packet and a lot of redactions in the comments. Could I ask you about that, and why are so many pieces of data redacted in the comments that we received today?
Courtney Arbor, Executive Director and Commissioner. I need to defer to our General Counsel to explain the full process for the redactions and what qualifies.
Thank you. Doug Jennings, General Counsel. Vice Chair Butler, and this can be an educational moment for the public too. Whenever we receive comments for the either written comments that are to be distributed to the commissioners for this meeting, or whenever we receive comments related to a rulemaking, what our teams do is they go through those documents and they redact personal information, personal email addresses, and telephone numbers. We received a question about this, I think just this week, from Commissioner Droxram. There is no need for us to make those redactions when providing those documents to you, commissioners, because you are not the public. You are our governing commission. It's been my understanding, asking some questions over the last couple of days, that practice of redacting those comments, that information from those comments for commissioners, goes back to a previous time when that process was established, because commissioners did not have a TDLR device or account, and those were being transmitted to them at perhaps their personal email address. And we took steps to ensure that confidential information was going to be redacted if it was going outside of the agency. So as we've made those changes, we're looking at that process. I'm actually talking with my team this week about getting you the full and unredacted versions in advance of your meetings.
I would appreciate that. I think I've had a TDLR email almost the entire 13 years I've been here. And so
it could be one of those standard operating procedures that just was fixed in time. And until someone asked a question about it, it just kind of kept moving that way. But we're happy to revisit it.
Thank you.
Thank you.
Chair, if I may.
Yeah.
Council, on the redaction of the personal emails and phone numbers, who are these rules for? Who asks those rules? Isn't the commission asking the rules to the general public? You all work for your employee next to you, the executive director. If a public is giving us the information, we need to see everything in totality. That we are not going to go and call them on the personal email or cell phone number or something. If you all think it is restricted, don't ever get that document to us. Because this is something it is for us to evaluate and make an informed decision. The reason why I asked is on one of the items which we'll go through to be redacted completely. We are trying to pass a rule and we need to understand the comment period. And I think if next time, if I do see something,
Yeah.
anything redacted, please don't bring it to us because maybe we shouldn't be seeing that. Thank you.
Understood.
Who'd like to go back and get the original, they'll contact you directly. Okay, Doug?
Yes, sir.
Absolutely. All right. Item F, we're talking about minutes. Commissioners, take a motion.
Chair, I got a question on the meeting minutes.
Go ahead.
I think in December, I kind of asked a question on our October meeting minutes. There was an item which was mislabeled. And I think, I saw that one on the meeting minutes that got corrected. But we didn't take a motion to vote on that one. It says it passed unanimous. I never voted because I wouldn't have voted on that one because there was a license issue for someone we are taking out their license and we don't have it correct right there. So there was a small item missing because in the PFD, there was supposed to be a correction made for the case right there, which we missed. So I went back on the meeting minutes and also the case to see it's just an oversight we missed. And that got to be corrected right there in order for that to be correct.
So your motion, do you want to make a motion to amend those minutes with that correction? Is that what you're making?
I was in the majority of Robert rules. I think, we need to call that open. Is that fair, counsel?
Doug Jennings, General Counsel. We reviewed, Commissioner Droxram, we reviewed those minutes in response to your concerns. And we found that they were accurate. I think, and then after, so if we will travel back in time to the last meeting, it was a little ambiguous. There was, we were discussing changes to the minutes, and then there was a motion and a vote. And so we construed that as a recommendation to make changes and approve the minutes as changed. Again, when we revisited, it's not just my eyes on it. When we looked at the minutes, they seemed to accurately reflect what happened in the meeting. And there was a motion and vote on those minutes, even though it was not very clearly stated what the motion was. And so we thought the fairest way to construe it, with kind of honoring your intent was to make corrections and then approve the corrected version. But we're happy to, they're happy to reopen this discussion if you feel very strongly about it, and we can discuss.
The issue here is you're trying to take someone's license out. And on one of the case right there, the PFD got to be amended with the corrections because your attorney-client privilege, the document shows we need to correct something. So if we don't correct it, does he have a recourse to go and appeal to the district court to say that they didn't follow their own procedures or something?
Commissioner, the order that actually implements that decision is absolutely 100% correct and reflects all the technical changes that were recommended.
Okay, I disagree, but sure, let's
Okay.
go on.
Is there a motion for these minutes?
And one more question, Chair.
Well, hang on. I'll make sure that there's not. I'll give you discussion just a second. Okay, go ahead.
So the other question is, in December, we had a licensee, which we're taking out on the towing right there. And we had about 5 members present and one recused, which is entitled. That left us 4 of us. So is it a majority of the commission members or the quorum for the licensing? Because we are taking his license away. And when you look at the signatures, it's only going to show 3 signatures being in affirmative and 1 nay. So how does it look like when it's a majority of 7-member commission?
Can't recall. Are you talking about the one where Dr. Callis recused
That's correct.
himself?
That's
There were
correct.
no 4 votes?
No, I thought we had, it said majority.
I'm not sure if that's the case. I think we had more than that.
I'll find the order and we'll circle back.
Okay, is that in
Later
this,
meeting.
is that in the previous minutes or is that the minutes before that?
I think it was in for the December meeting.
December, that's in the December.
Okay, okay. So do you want to check that before we even come back and have that motion?
Yes, thank you.
All
I
right, I'll
make a
give you-
motion that we table this until we make sure we have a quorum.
Okay, and we'll check that. All right. We'll come back to that item. All right, Dr. Callis. All right.
Yes, sir.
Contested cases. We're gonna go to item G. I think we have one, Jessica Tata. Doug, let me know when you confirm that.
Good morning, Chairman, Commissioners.
Good morning.
Are you ready? My name is Jessica Hurtado. I am a prosecutor in the Enforcement Division. The ALJ recommends that you deny Janicia Bethia's application for a cosmetology operator license based on her criminal history. I ask that you adopt the PFD as written. In 2016, the applicant pled guilty to and was convicted of conspiracy to sex traffic persons, a felony offense. The victim was a minor child, and the applicant was sentenced to 4 years in federal prison, followed by 3 years of supervised release. However, in 2021, she violated the terms of her release by failing to register as a sex offender and failing to participate in court-ordered treatment. She was sent back to prison for 5 months, following an additional 2 years supervised release. However, she again failed to participate in the court-ordered treatment and was again sent back to prison. Crimes involving prohibited sexual conduct or involving children as victims, and crimes involving human trafficking are guideline crimes for the occupation of cosmetologists. Licensees have direct contact with members of the public, including children, often in settings with no one else present. Additionally, a cosmetology establishment can provide an effective cover for the sale of services by victims of human trafficking through forced labor. A person with a predisposition for committing these types of offenses would have the opportunity to engage in further similar conduct if licensed as a cosmetology operator. In analyzing the Chapter 53 factors, the ALJ found that 2 of the factors weighed in the applicant's favor: the fact that she was 18 years old when the offense occurred, and the amount of time that has passed since the offense occurred. However, the ALJ also found that the offense is very serious and resulted in a prison sentence. Additionally, the remaining factors weigh against the applicant. The applicant's rehabilitative efforts were minimal at best, and the applicant's failure to comply with the terms of her supervised release, resulting in her being sent back to prison on 2 different occasions. Finally, the applicant provided no letters of recommendation from members of the community or other evidence to support her fitness for licensure. Therefore, the ALJ concludes that the applicant is not currently fit to be licensed and recommends that you deny the application. I ask that you adopt the PFD as written. I'm available to answer your questions. Thank you.
Thank you, Mr. Tata. Any questions, commissioners? All right.
I have a question for Mr. Tato. The question is a generalized question. If these licensees that don't have a license and they go to a place that is licensed, i.e. an establishment, and they get a job, is there any recourse on that establishment that is basically not following lawfully that you must be licensed to do things in the state of Texas?
Yes, Commissioner, that would be a violation for hiring an unlicensed employee.
So has she been, since she's been unlicensed, has she been hired to do any cosmetology by anyone? Or do we see a lot of that?
Doug Jennings, General Counsel. Dr. Callis, I appreciate the question, but it's likely outside of the administrative record. So we
All right, well, thank you. Thank you.
Yes, sir.
That's fine.
Okay. Any further questions?
Is this the one that lists some modifications to the PFD as needed?
Doug Jennings, General Counsel. Yes, Commissioner High, we have reviewed the PFD, and in findings of fact 16, 17, 18, and 19, it looks like there were some incorrect dates that did not match the record, and so we've recommended to make some corrections. And Mr. Hurtado, please let me know if you disagree with any of these. In finding of fact 16, it should reflect that we proposed to deny the petitioner's application in 2025 instead of 24. In finding of fact number 17, the petitioner requested a hearing on March 24th, 2025, instead of January 27th, 2025. Finding of fact number 18 will modify it to clarify that the month that this case was referred to SOA was April and not February of 2025. And then finding of fact 19, we correct a date from March 12th, 2025 to April 14th, 2025, when the department sent the notice of hearing to the petitioner. Those are the four, they're all technical changes under the APA.
Okay. Any questions about that? Okay. I'll take a motion.
Chair,
I make a motion to adopt the PFD with the changes iterated 16, 17, 18.
Is there a second?
Second.
All
and
right.
19,
Second.
Dr. Callis.
19 too, sorry.
Thank
Yes,
you.
sir, 19 too.
We have a motion first and second. Any further discussion? All in favor, say aye.
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 Opposed? All right, motion carries. Thank you, Jessica.
Thank you, Commissioners.
All right, Doug, did you have anything on the minutes that you want to come back on?
Not yet, Chairman. I would like to follow up at the end of the meeting, if that's okay.
That's perfect.
Thank you. And I just, for the record, want to note that items number 1 and 3 under G, contested cases, have been continued to the next meeting due to some scheduling issues for TDLR staff. Thank you.
Okay, we'll go to item H. Bostic. Good morning, Ms. Bostic.
Good morning. My name is Michael Bostic, Assistant General Counsel. Today, I'm presenting the consolidated rule review for the 11 chapters listed on the agenda today. The Administrative Procedure Act requires state agencies to review their rules once every 4 years to determine whether the reasons for initially adopting or readopting the rules continue to exist, and whether the rules should be readopted, amended, or repealed. TDLR handles this in rolling blocks. So for the 11 programs we have listed on the agenda today, each GC assigned to the program has gone over the rules with internal and external stakeholders to determine if the rules are still authorized by their respective statute and they are necessary to achieve their stated purpose. Following that internal review, notice of intent to review for these programs was published in the Texas Register on August 15th, 2025. Any public comments regarding the adoption or repeal of these rules has already been taken under consideration as part of this review. Comments suggesting changes to the rules that weren't otherwise related to this review will be taken under consideration for possible future rulemakings. Based on our review and the public comments we received, we did determine that the reasons for adopting or readopting these rules continue to exist. Therefore, we recommend that you readopt these 11 chapters in their entirety and in their current form with an effective date of February 27th, 2026. Thank you. I'm available for any questions.
Thank you, Mr. Bostic. Commissioners, any questions? I'll take a motion.
So moved.
Second, with the adoption date of February 27, 2026.
Thanks, Commissioner. All those in favor say aye.
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 Opposed? Motion carries. All right, Mr. Bostic, item I.
Good morning once again. Michael Bostic here, Assistant General Counsel. So this is the proposed rule package implementing SB 2371 from the 89th legislative session. This bill created Chapter 607A of the Texas Business and Commerce Code, which requires all merchants to report skimmers on electronic terminals to the Financial Crimes Intelligence Center. In this context, electronic terminals are devices used for consumer transactions like point-of-sale terminals and ATM machines. These rules create Chapter 63 within Title 16 of the Texas Administrative Code to establish the procedure that merchants must follow when reporting skimmers on electronic terminals to the FCIC and when removing those skimmers. Just to briefly go over the requirements and the rules, when a merchant discovers a skimmer on an electronic terminal, the merchant must first report the skimmer to law enforcement and FCIC using the FCIC secure portal on their website. The merchant must also take steps to disable the affected terminal and block public access to that terminal. If law enforcement or the FCIC has not removed the skimmer within 24 hours of reporting, then the merchant may remove the skimmer themselves by following the procedures outlined in the rules. The proposed rules were published in the Texas Register on November 14th, 2025. We did receive one comment from the Texas Food and Fuel Association, which requested that we remove the administrative sanctions and penalties section from the rules because they contend that Chapter 607A does not grant the department the authority to issue administrative penalties for violations of the statutes and rules. We reviewed and we disagree with this comment because the department is authorized to impose administrative penalties for any violation of the laws and rules of a program that we administer. And in this case, the FCIC is established within the department, and Chapter 607A, the newly created law, explicitly directs the department to administer the program through FCIC. Therefore, we do have the authority to administer penalties for violations of the law and rules, and we have made no changes to the proposed rules based on that comment.
Thank you.
This proposed rule is being presented for your review as it was published in the Texas Register, and I recommend that you adopt the proposed rules with an effective date of March 15th, 2026.
Now, thank you. Appreciate that, Mark. Commissioners, questions?
Yes, sir.
Yes, sir.
Council, if you look at this one on any terminal, are restaurants included in this one? Because lately you have the portable ones coming in.
Skimmers on electronic terminals.
Yeah.
So electronic terminals are specifically defined within these rules and within the law as it's devices through which consumers interface with merchants to conduct financial transactions. So it would be every electronic terminal that a merchant uses to conduct that financial transaction with a consumer. So to your question, you said restaurants?
Yes.
That would be covered.
Okay. So we got broad spectrum of anyone who does financial transactions on a credit card are covered under this one. Fair enough?
That's correct.
So any vending machines that also are covered under if they have a credit card transaction capability.
Yes.
Okay. So assuming we published it, we only got it from the Fuel Association, Food and Fuel. Rest of them all are quiet.
We have conducted outreach through FCIC, through various trade organizations. And yes, that's the only comment we've received so far.
So we have done our due diligence.
Yes.
Thank you.
Yes, sir.
Thank you, Mr. Chair, Commissioners. Just kind of a note. I like where we're going with the FCIC. I like what the FCIC has become and what it's going to be. It has saved hundreds of millions of dollars from Texans, Texas financial institutions, and has gotten a lot of bad guys put away. I would just caution the agency, please, going forward. We're now asking private companies to partner with us, essentially, in helping to fight skimmers. But when somebody shows up at your place of work and says, I'm with law enforcement, the Financial Crimes Intelligence Center, it could be very intimidating to a family that runs a gas station in a small town. We don't want the heavy hand of government, especially this agency. The DNA of this agency has always been to partner with the industries that we regulate. We're here to help make life better for you. We don't want to lose that as we start to expand our law enforcement capability and our footprint to be an intimidating agency. That's the last thing we need. That's contrary to who we are. We need to say, we are here to help you. And the only people that can make that statement and make it real is the TDLR, right? Because we're the ones that are going to implement this on the ground. And so please make sure that as we roll this out, that we take everybody into consideration and put our arms around them and say, we're in this together. We're not here to force you to do things. We may have to if you don't work with us, because this is for the betterment of every Texan. And we're all in regulated industries up here. And so when regulated industry comes to call and says, I want to inspect your books or take a look at what you're doing, especially if you have a badge and a gun, that's very intimidating, right? So just remember, we're the good guys. We're here to work with the good guys. And I don't want that fact to be lost on them when we show up. And so please just kind of take that into consideration as we roll this out to say we're here to help make life better. We're not here to run over you as a state agency. And my fear is as we get bigger, we don't want to lose the DNA of this agency and what brought us to where we are, the success that we've had. We don't want the world to change us. We're here to change the world for the better. And that's why we've been so successful. So please keep that in mind.
Thank you.
Any other comments? Okay. I echo Commissioner Vice Chair Butler's. I've been to the center. I know what the center looks like. I know the vulnerability associated with the fiduciary responsibility that those vendors have on capturing the credit card information and financial data of every Texan here. And there, we want to make sure that it is a broad stroke, it's a broadening, and we have to make sure that, to Commissioner Dockstron's point, that we are checking with all the actors that are involved and making sure they don't get blindsided by this. So we want to make sure their opinion, keep us posted on this. But the genesis of this was the idea that most people or most vendors didn't report this. Nickels and dollars add up, millions of dollars that funded a lot of illegal activity throughout the state for a long time. Because if they don't get noticed, then it just continues to say. So I'm fully aware of the capacity of what we're trying to do in regards to relegate the funding of illegal activity through these skimmers, because they are organized crime, those things like that. But in that vein, there should be a caution in regards to how we approach the vendors, making sure that we are hand in glove with them, but also that actors who may not be aware that this is going to affect them, or the possibility that they could, that we are making sure welcoming their comments and not doing this in the 11th hour. Okay. And I think that's, we need, so I would ask you to keep us abreast of what's going on in regards to how this is implemented and the expansion of it, because it's new ground for us. Okay.
Okay.
All right.
Chair, if you may ask me to, I want to make a comment. Hopefully on our webpage, we are going to be making sure that all of them are going to be regulated or, report or something. We're going to have something on our webpage, I assume, correct?
That's correct. And we already have some instruction for merchants because the law is already active. So these rules they fill in the remaining gaps and really are intended to give the merchants instructions for how to report the skimmers. And so we have put things up on our website to that effect.
Perfect. Thank you.
Good. All right. Any other questions, comments? All right. I'll take a motion.
So
Make
move
a
to,
motion. Go ahead, Dr. Dawson. Go ahead.
so move to adopt the rules with the effective date of March 15, 2026.
Second.
All right. We got a motion second. All those in favor say aye.
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 Opposed?
Aye.
No one opposed? Motion carries. Thank you, Mr. Bostic.
Thank you.
Good job, Mr. Bostic.
Thank you.
Okay. We are going to go to item J, penalty matrix. Medlock.
Good morning, Commissioners. My name is John Medlock. I'm the Chief Prosecutor for the Enforcement Division. I'm bringing forth today two different penalty matrix, one for the dyslexia therapy program, the other for the orthotis and prosthesis program as well. These updates to these penalty matrix were both reviewed by both advisory boards for these programs and unanimously adopted and approved. The updates include citations to rule citations and statutory changes that were due to legislation, as well as the addition to some CE violations that were added to because of this legislation. Essentially, I would just ask you to adopt these changes so that we can publish this in the Texas Register and begin to use this in the Enforcement Division.
Okay. Any comments, Commissioners? All right. I'll take a motion.
So move.
Is there a second?
A second.
All right. All those in favor say aye.
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 Motion carries. Thank you, Mr. Medlock.
Thank you.
Cassie. Item K. Cassie, is it Sapseed? Ted. Sorry, Sapseed. Got it. Thank you.
Good morning, Chairman and Commissioners. Cassie Sapstead, Assistant General Counsel. As we have discussed in previous meetings, the existing process for evaluating requests for continuance from contested case respondents has proven to be confusing and unhelpful for respondents. In an effort to reduce that confusion and provide greater clarity to respondents, TDLR staff, and the Commission, General Counsel has created potential changes to the process for your consideration. Additionally, our research and outreach to other Texas agencies has shown that TDLR is an outlier in the way that motions for rehearing are heard at Commission meetings. We have also put together a recommendation for a change to that process to put us more in sync with other agencies. I will be discussing both of our recommendations today. First, our recommended process for requests for continuance would begin once a respondent submits a request for continuance by email to General Counsel. General Counsel will then forward the request to enforcement, specifically to the chief prosecutor and to the prosecutor who handled the enforcement case. Enforcement will respond as soon as possible, either in agreement with the request or with an objection. If the respondent states a valid reason why they're unable to attend the meeting, such as illness, work scheduling conflicts, lack of transportation, and so forth, then GC will then do the following. First, we will ask the respondent if they can attend remotely. If so, General Counsel will coordinate the respondent's virtual appearance at the Commission meeting. If the respondent is unable to attend remotely, GC will grant the continuance unless enforcement provides a compelling reason not to grant. For example, if hearing the case is time sensitive or if there's a deadline. Assume that enforcement has not provided us with that reason. After granting the continuance, General Counsel will then send the respondent notice that they are to appear at the next scheduled Commission meeting. As I've already previously touched on, General Counsel will ask for enforcement's input regardless of the reason provided by the respondent. Let's assume enforcement provides a compelling reason not to grant the continuance. General Counsel will then contact the chairman for direction on whether to grant or deny the request. Everything I'm talking about right now applies to first requests for continuance. And those first requests for continuance will be granted if the respondent provides a good reason and is unable to attend virtually. For second requests, those will be denied unless the respondent can provide documentation supporting the continuance. And then from there, any further requests for continuance will be denied automatically. We have discussed this recommendation with enforcement, and they are in agreement with our suggested changes. Before I move on to our recommendation for motions for rehearing, I'm available to answer any questions you have.
Questions, Commissioners?
I do have.
So they basically get a free hall pass on the first one because we're not going to be, if they say that they can't drive, they can't, they're sick, they can't do anything, then we're going to offer remote, but we're going to be a lot more lenient. But on the second request, we will definitely make them have documentation. Is that the way I understand it?
Yes, that's correct, Dr. Callis.
Thank you, ma'am.
Yes, sir.
Sure. The statute pretty much dictates that the complaints, we have to go promptly and efficiently right there. And it went through the hopper because, again, it's about the safety of the Texans right now. And what we see is we are adding more burdensome to the staff right there because, again, one part of the statute somewhere it says that we can't be wasting public money right there. In doing what has been prescribed is basically we are going through general counsel, enforcement, they got other stuff to do right there. I'm not in favor of anything right there. If you can't make it, you can always do an informal, there is always a rehearing right there. Because what it is we got so much in the hopper and it is showing that one we are delaying the safety of any enforcement actions right there. I think we need to be in control as a commission And if someone doesn't want to come, I understand illness right there. The work right there, if they can't come on to work, it's about a 5 minute or 10 minutes of virtual stuff right there. I think we can't be kicking the can down the line and expect that the enforcement, the backlog to be gone right there, because we got a lot of work right there, and internally it keeps on going back and forth, do loop right there that let's do this one, then we can figure out this. I think we need to cut everything. If they can't make it, we can always do informal, which we have done in the past in previous commissions. And they always have a rehearing right there, for which they can come. Okay? Right now, for a rehearing, they don't come. They can send a request, and we, the commission, decides on the rehearing. At the rehearing, they can come on their own time whenever it is. But we got to act in the interest of public safety, because most of them, the cases what we get are nothing related to, what is that? They've done a bad job or something. Most of them are criminal in nature right there. The better we act quickly, it's better for the public safety right there.
Ms. Sapstead, why don't you explain to Commissioner Dr. Ram how the current process and the modifications you're requesting, and then making sure that to his concerns, which is the backlog that maybe we can remedy down the road, which is maybe this is a step, but also without infringing upon the due diligence that needs to be done for the public when they are to give them their fair day. Could you address that a little bit on this continuance?
Of course. Commissioner, I think a lot of a lot of the thinking behind modifying this process is so that we are approaching these in a uniform way, right? So if we do have folks that for whatever reason something comes up, and I totally understand your concerns and hear you, like we don't want a backlog here. I think enabling them, having a process in place where we say, hey, can you attend remotely? Then we're removing kicking the can down the road, so to speak, right? Because then they're given that option. And so I think a lot of this, and Doug Jennings can jump in too, if he would like. I think a lot of this is trying to eliminate the confusion across the board for respondents, because they don't know what if something comes up. They don't know if they can ask for a continuance. And also, again, in order to get rid of that confusion, we want the consistency too, of we want to be offering every respondent. Again, this is for first request. This is not someone who we're at the fifth request, right? We're not interested in that. So this is really the first request. We want to make sure we're offering each of these respondents the opportunity to appear and, argue their part of their case, right? So, Doug, do you?
Yes, sorry, new technology. Thank you, Ms. Sapstead. Doug Jennings, General Counsel. Yeah, I just want to just piggyback on what Ms. Sapstead said, is that this is your process to determine, right? I think that's our starting point, but providing that consistency and removing guesswork from a respondent. Let me just give you an example about how things are working currently. And this is why we're saying this is a little confusing. If a respondent receives a notice from the Office of General Counsel that says your contested case will be heard by the commission on February 18th, and then they reach out to us and say, I have to work that day. I've been unable to change my schedule. What we have said to them in the past is, okay, well, if you can't make it on the 18th, send us in writing a request for a continuance for your case to be heard at the next meeting. But what we then have to tell that respondent is, but you should probably be at this next meeting anyway, because the commission has to vote on it. And so you can see how that kind of yields an absurd result, right? We're telling a person who's told us that they are not available, that they need to be available so the commission can rule on their motion for continuance. And so whatever process we agree on today, we just want to make sure that it's consistent and that it's just offered to everyone, because we have seen a recent instance where a first request for continuance was just denied by the commission. And we collaborated, Ms. Sapstead collaborated with enforcement on this to trying to find that space that both honors our workload, but also tries to honor, a respondent who may have a genuine reason for not being available. But there are options. if, if the commission after discussion decides that, continuances should only be granted in very limited circumstances, we'd like to know what those circumstances are so we can incorporate that into policy. If the commission wants to say that second requests will be denied across the board, then we'll incorporate that into the policy. So you have some room here, but and Commissioner Droxram, 100% agree. We're a very busy agency, and whenever we have to kick the can down the road, there are some costs. We're just, this recommendation that Ms. Sapstead has laid out, we're just trying to find that middle ground that's fair to respondents and to the agency.
Okay. Dr. Gorsuch.
But, I just have a quick question. So in that first letter that goes out, the option for remote is included in that, correct? Or do y'all just put the date? Your rehearing is set for this date, and they don't have an option for do video on that first time they get the letter?
So this is, I just want to make sure that we have not yet talked about motions for rehearing, but when a respondent gets a notice that their contested case will be heard by the commission, since we kind of transitioned into the return to office post-COVID, we have not included that virtual remote appearance as a default option. And so a respondent would need to contact us and request that. And so that's why we've built this into that process. If that person is unable to attend in person, they could request either a virtual appearance or that their case be moved to the next meeting.
Okay, so doing an option with a video wouldn't keep from kicking the can down the road, because then we've got to, and if it's just on rehearings, that's fine, as opposed to the first letter.
So I think what we were what we're hoping for is that if we agree on a policy today, we will articulate that policy in the letter that Office of General Counsel sends to respondents. So for example, we could say, depending on how we agree today, we send the notice and then we say, here is our policy for requests for continuance. We could be silent about it. They could simply email GC and request one, at which point we could tell them what their options are. I mean, that we really have, you do have some options here. We're just trying to get out of that uncertainty where someone says that they can't be at a commission meeting, and we tell them that they really need to be in order for their request to continuance to be heard and decided upon.
Okay, thanks.
Yes, go ahead.
Mr. Jennings, are there some compelling reasons to not give them the option at the first hearing of the virtual?
That's Commissioner Butler. That's for the commission to decide. I mean, I think the process that we have laid out when we talk about compelling reasons, for example, if the respondent puts in a motion for continuance, the attorney assigned to that case in GC will contact enforcement. Is there any reason that this case needs to be heard and the continuance should not be granted? And that could be something as simple as there's a deadline. It could be something like, this is a high priority case. This is a dangerous individual that, kind of one of the points raised earlier. We really need to finalize this decision, and we don't need to continue it. So those are the kinds of things that we could reasonably expect to get, to hear from enforcement if the case is high priority. And then, as Ms. Sapstead laid out, if we have, if the respondent has provided what, we categorize as a good reason, and in the materials you have, it's illness, unavailability due to work, we would, the process that we have recommended would be that we have essentially a tiebreaker by asking chairman, to kind of resolve that, grant continuance or not. That doesn't have to be the way that we do it. This is just, again, this is our proposal to you to just try to resolve these and provide some consistency and to make sure that these are all handled in the same manner.
Are they given the option at the time of initial hearing of video then?
Before SOA or for this?
Anytime in our process, are they given that option?
Yes, I believe, and enforcement, please correct me if I'm wrong. So They're all virtual. Okay, that's at SOA. All of those hearings are virtual. But since we have mentioned that since we've come back into physical presence in these meetings, we have not extended that option initially, and we certainly could if the commission wants to adopt that process alongside changes to the continuance process.
So let me come in here. Okay, so we want to, and I think the great questions. We're building a plane and flying it with this virtual because I think we want to make sure build parameters around this. We don't want somebody. We stumble on ourselves, and the efficiencies lose quickly when we can't log people in, or they're not in the right place. They can't be heard, or they don't understand technology. So I want us to be careful as we allow this Pandora's box of virtual become open, that there are parameters associated and guidelines that have to be followed so that when we do bring that case up, it is not stalling the whole commission based on a technical difficulties or inability to do that. So I don't know if we've adapted that yet or if we've been able to garnish that when we have to talk to IT. I am saying that it is important that we process these as expeditious as possible, but with the idea though those guidelines are hard and fast so that when we get there, we're not stumbling on ourselves. It's one thing to stumble with commissioners, but when we're stumbling on each case trying to figure out, and they're, especially if they're not technically savvy about what they're trying to do. So we want to make sure that's first. Just want to add that 2 cents as we build this out. Now, also commissioners, this isn't a static process. We're evolving this process, and so we can ask GC to continue to build and to figure this out. So we don't have to have it seamless today. This is just an effort I think if Cassie has made to be able to help the concern of a backlog and to delay the tactics to be able to have a first step. So I just wanted you to know that this isn't a set in rules and we're done. We can come back on next commission meeting and modify it even more. So just giving those 2 headlines.
Thank you, Chairman. And I just want to add, kind of honor your perspective there is why we have not in our notice letters to respondents kind of given them by default an option to appear remotely and why we recommended in this policy that person might request a continuance first or have to put in a request in order to get that, to have the opportunity to appear remotely because I know, the desire to have an in-person presence. Just wanted to also mention, thank you, Ron Foster, our director of our enforcement division, has informed me, said it does benefit enforcement as well to have that person available, the respondent available even remotely at that commission meeting, because that means that they made that meeting and that case is still on track and not being continued. So, we do believe, it looks like across the board, we believe that providing that remote option to a respondent who indicates that they cannot be make the meeting in person would be beneficial as part of this
we're
process.
on the same page on this. Okay, we just want to get it more efficiently. Just want to make sure we do it right and with guardrails, because we've had incidents where technology has not been our friend, and so we don't want to delay the commission.
Chair, if I may comment something?
Yes, go ahead.
I understand, people have issues come up right there. In my past commission, the judges, okay? We went through this one. So the continuance was building the backlog right there. And I think back then, the commission took action. Continuance is only the commissioners trying to get it, and it has to be something valid, probably not. I think that if a date has been set by the staff, that is a day they have to appear either remotely or whatever it is. If not, an informal, it will be taken. And then again, they have this rehearing right there. Because if you look at it, the last 3 years I've been seeing, most of them are criminal right there, convictions right there, which by statute, we can't do much about it. It's pretty much standard right there. So how many times we have seen it on all this activities like, what is that? Most of them are sex and drugs or something, and we don't have any control. Do we need to have those people licensed and continue for last, whatever it is from the day SOA gets in or a district court convicts them and come back? And I think, we are not holding ourselves accountable. We got to get these people off license so that Texans can be safe.
Okay.
Thank you.
Any further comments, commissioners? All right, I'll take a motion.
Doug Jennings, General Counsel, just a couple of points, if you don't mind. Commissioner Drockstrom had mentioned motions for rehearing, and that's going to be kind of the next part of this discussion. And so,
You want one big motion for both of them?
well, I think maybe perhaps we wait until the end to make a motion to make sure that they are consistent and that that
Okay.
the processes work
Okay,
together?
You're fine.
Okay, thank you.
Let's just hold off you had me at hello. Okay. Go ahead, Cassie. Go to the next one.
Currently, motions for rehearing, again, Cassie Sofstad, Assistant General Counsel here. Currently, motions for rehearing are added as an agenda item during commission meetings. And someone from General Counsel and the respondent appear before the commission to advocate for granting or denying the motion. General Counsel's recommended change to the motion for rehearing process is for the commission to delegate the authority to General Counsel to rule on motions for rehearing and remove motions for rehearing from commission agendas entirely. Of the several other agencies we surveyed, we were unable to find an agency whose governing body or commission considers motions for rehearing during their meetings. Rather, the agencies we spoke to reported that their general counsel considers and acts upon motions for rehearing. General counsel has a team of attorneys in place with many years of legal experience involving contested cases who carefully vet each motion for rehearing for any errors committed by the agency, as it is very important to us that the agency get the decisions right. Along with this process change, we would be happy to provide ongoing reporting about the number of motions for rehearing received and how they are being ruled on. This could alert you as the commission to any trends if you become concerned the motions for rehearing were not being handled properly. Again, I'm available to answer any questions you may have about our recommended change to motions for rehearing.
Questions, commissioners?
Yes, sir.
All right.
Mr. Chair.
Vice Chair.
So one of the great things about this commission, and thank you for the work that y'all are doing, a tremendous amount of work and very reasoned and considerate. I love that. But the reason that we're not, we serve on this commission because we're not regulated by any of the industries, obviously, that we see. So we bring a fresh set of eyes, right? An objective frame of reference for the people that come before us and say, I need some help here. I'm a little apprehensive about taking away, I view it as a protection. And there have been a few instances in the 13 years that I've been here. One comes to mind of a property owner who was trying to do everything right. They received it was a leasee of a property owner that received a notice from architectural barriers, and they were charged $600. They paid the $600, but the architectural barrier had never been addressed, and they didn't own the building, but they received the fine, and they showed up and said, "Well, we're happy to do whatever. We just don't own the building," but we continued to go after them. And it was brought up in that motion for rehearing that they weren't the property owner. And so it's just one anecdote of many that wouldn't have surfaced had we not do that. So the argument that every other agency does it this way, that's why they don't get all the programs that we get. We're doing something right. In the marketplace of governmental services, we are winning. Why are we winning? Because we listen. Why do we listen? Because it makes us better. So that's the feedback loop. And I think you're trying to take away one of those cogs in the feedback loop with this policy. I'm uncomfortable doing it because we are a protection for Texans. This is a protective procedure that we have in place. So that's my opinion. And
Okay.
Thank you.
Any further comments?
Yes, Chair. I think I echo what Commissioner Butler has said. I think this is a final say on what got to be done. I think we need to preserve the right to do on the continuance or rehearings or all of them. I think we need to also be efficient in trying to do what got to be done, because by the time the case hits the hopper with the enforcement and comes right here, the time lapses of about 1 to 1.5 years right there. I think we could do better, and I think I agree with what Commissioner Butler has said. Thank you, Chair.
Any other comments?
Chairman, may I respond?
Yes.
If you mind? Thank you. And Commissioner Butler, I completely understand your perspective and anticipated that would be part of the commission's response. And so that's why, and that's why our proposal we were trying to strike a balance, right? When I think about the various types of motions for rehearing that we get, that you have seen over your tenure, they usually fall into 2 or 3 buckets, right? I think we have seen, I think the most common is a person receives an NOAV, it's properly served, they don't respond, they don't request a hearing, and so there is a default order issued against them. And they may, they'll file a motion for rehearing that says that it was sent to the wrong address. But we have rules in place that say you've got to keep your address updated, and oftentimes they have not, right? So those will come to you. We will see, especially in hotly litigated SOA cases. I think this is perhaps kind of the prompt for us to have this discussion. Is what we have seen is we'll have a rather technical SOA case. There will be the ALJ in that case will make rulings on the admissibility of expert testimony, on make all sorts of rulings about the admissibility of that evidence on hearsay or other grounds. And what we end up with after the commission makes its decision and that commission order is sent, we end up with that respondent trying to relitigate the same issues they had just appeared before, and trying to litigate purely legal matters. I think one of the things, and this is not a slight to the commission at all, but when we see the types of motions for rehearing that are in that clothing, where they are purely, this evidentiary ruling was erroneous because, we'll see motions for rehearing that are 3 pages long. A lot of case law citations, I view that as something that, my office is able to interpret and give you good advice on, but they are in many cases just trying to take the second bite at that apple, and we're trying to identify error, right? And so I guess what I'm saying is I have seen, at least in my tenure here, a difference in the way kind of the commission's appetite to make decisions in regard to like default orders versus we made that decision at the last meeting and now you're making the same argument again. So what I'd like to ask, and I'll just speak specifically to you since you've articulated this. One of the concerns that I've had personally, I won't speak for the agency, but I've had is, as you've said, there are a lot of things that TDLR does well, really well, and super well, and there are some opportunities where, for example, the Administrative Procedure Act says you get 1 notice and you get 1 hearing, right? And instead, what we do is we send them an NOAV, and if they don't respond, we send them a notice of default, and then we send them a default, and then they get a motion for a hearing. And so there are many bites at the apple, and we've kind of built in processes to give more than the law requires. But when we have one of the frustrations I've encountered is when we have a motion for rehearing, and we'll have someone who sent in a written motion that says argument A, B, and C, and then they'll come before you and give D, E, and F, right? And don't get me wrong, it may be compelling. It may trigger your sense of perhaps something unfair has happened. But it puts us on our back foot a little bit because we weren't able to, in many cases, prepare to respond to that argument. And so what I'm wondering is if the commission desires to keep its power to resolve motions for rehearing, if there is perhaps a wrinkle to the process where we could strictly make it through writing, for the commission to evaluate, the respondent's motion for rehearing and perhaps a response from enforcement, which my office can then mediate, provide recommendation to you for you to make a decision without having the parties come and kind of have another hearing where they present new and different arguments.
I think those are great arguments. I really do. I think, yeah, you make some wonderful arguments, and I'm sure from your perspective, it's like, well, what did they have for breakfast today? Because that's going to determine the decision that they make. And you're probably right. and I had nothing for breakfast today. So maybe I'll be consistent on days when I don't have breakfast. And then you have to defend what we do in court, and I'm sure that's never fun, right? And I love the arguments that you made. There's one that I would take issue with. It's taking power away from the commission, is the way you phrased it. I view it as taking power away from Texans, from the guy that comes up here. And he's surrounded by everybody in government, right? And he says, "Please don't take my license." And then that's the way I view it. I don't view it as you're taking something from me as a commissioner, and I have enough to worry about. Yeah, I could use one less thing to have to decide. But if I'm that guy, I want somebody up here saying, "Please look one more time. I think I've been done wrong. Please look one more time." My dad worked 38 years in construction. I got my start pulling welding leads, working my way through junior college. Took me 6 years to get my 2-year degree because I was working construction during the day, going to school at night. That's who I am. And that's what I bring to government, right? And so I'm always going to be looking out for that guy. Don't be confused because I'm on this side of the desk today. Because tomorrow I may be on that side of the desk. And I would want someone like me to say, have we looked? Have we done everything we can before we take this guy's livelihood away? So that's my perspective. And I appreciate your arguments. I really do.
We're on the same page, Commissioner Butler.
I think we are. Anyway.
Okay.
That's enough.
Any other comments? Oh, go ahead, Nora. Commissioner Castaneda. You're on mute.
Doug, so what you guys want to do, general counsel wants to, cases that are being brought forward, are you trying to weed them out before you bring us the questionable ones? Are you trying to do work for us and bring us the final say, or how's the streamline for this?
Commissioner Castaneda, I'll just give you just a brief history. So many years ago, let's see, I just hit 10 years with TDLR. So I think I started working on motions for rehearing perhaps about 9 years ago. At that time, anyone who filed a motion for rehearing, it essentially went straight to the commission. It was, there was some research, and Della Lindquist would review the record and make a recommendation. Along the way, we realized that there were certain respondents that would say, I'm filing this motion for rehearing because it was sent to the incorrect address. We'd review it, and that was absolutely correct. And it seemed a little bit odd to us to have to tell that respondent to show up at a commission meeting, to drive to Austin to make that argument. And so we asked the commission, when we're reviewing these, if we see an error, we asked the commission to give us authority to correct that error. And so we've been doing that. There's a reason you don't see a lot of motions for rehearing. Well, I won't say a lot, but there's a reason you don't see some motions for rehearing. It's because when we go through that rigorous process that Ms. Sapstead articulated, if we see an error, we'll look into it. We'll ask our executive director to vacate that case, so we will not proceed with that error. And so what you have been seeing, Commissioner Castaneda, we have been taking to you only those motions for rehearing for which Office of General Counsel would recommend denial. If we think it should be approved, we're just going to, you've given us authority to take care of that and fix that error in-house without having to send the commission, the respondent, to a meeting. So that's the power that we have already. And I just want to make sure I'm characterizing it properly is, we view the continuance process and the motion for rehearing process as really linked. And so it is true that other state agencies handle motions for rehearing in a different way than this commission. There's nothing prohibiting us from handling it the way that we're handling it. So we're really, I don't want to characterize this as a request to stop doing this. I think where I was coming from was behind the scenes, there's a very rigorous process that happens that you're not privy to generally. I'm happy to talk to you about at any point about it. That does vet these. And so all the request was to delegate the authority to general counsel to make those determinations on motions for rehearing, to approve or deny. But at least what I'm hearing from Commissioner Butler is a desire, not to delegate that power. And this is, I mean, that I think it's well articulated, and I don't object to it.
All right, well, let me cut the, okay, so let's just do this. Commissioner Butler's got his opinion. We got, other commissioners. So, commissioners, is there any other questions that you have particular? If not, we can either one table this motion for another some more time. We can move them on the motion. But is there any questions that we need to
Could
have on
we
this?
give the licensee an option whether they perhaps coming in front of the commission would scare them? So could they have the option of going through general counsel or coming and speaking to the commissioners?
That's an interesting question. I think it would put, I'm just speaking for myself here, but in my division, I think it would put us in a bit of a strange spot if we were to have kind of a separate proceeding for a respondent to appear before us to make an argument. What we do in the motion for rehearing process is, they'll send us their, typically through an email, sometimes a letter, where they state, here's where I believe why I believe this decision was erroneous, and they have that opportunity. Once they provide that detail, we open the door for them to come to the commission and kind of refine and provide their argument to the commission. I'm open to some discussion about this, but I think perhaps a separate meeting, separate hearing would not really be the
point,
solution.
Maybe we can table this motion. Look, we've gone from we're backlogged to everybody needs to hear. So there's obviously the commission's still trying to understand this and wrap this. Why don't we table this motion and give the commissioners and individuals time to be able to speak directly and understand the process? Yes, Dr. Callis.
So that way we have it on record and it's documented in the minutes. Make a motion to table this until we further the discussion.
Second.
Second.
All in favor, say aye.
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 Opposed? Okay, motion carries. All right, there you go.
Thank you.
All right, commissioners.
Thank you.
Yes, we're going to go to item L.
Mr. Jennings, Ms. Abstead, thank you so much for your.
You done? All right, Funderburg, Mr. Funderburg, item L.
Mr. Chairman,
Yes.
can I ask to be excused? I have the governor coming to Beaumont in less than an hour and I have to go be with him.
That'd be a hard no. All right.
He'll understand.
All
He'll
right, well, I'll let
understand.
him know,
That'd be
sir.
a hard no. And make sure you give him Butler's number. That's fine, Dr. Callis. Thank you for your time. Oh, Dr. Callis, I'll follow up with you. There'll be some other, but non-voting items. I'll just follow up with you directly. Okay.
No problem. Thank you very much for allowing me to adjourn so I can go be with him. Thank you very much.
Mr. Funderburg.
Good morning, Chairman, Commissioners, Assistant General Counsel. Chris, you need to turn your mic on, please. And could you start over? I'm sorry.
I'll start over. Excuse me. Good morning, Chairman, Commissioners. I'm Assistant General Counsel Christopher Funderburg. This section of the agenda is the department's report in response to a request this commission made at its December 6, 2024 meeting. First, I'd like to provide some background for this report. For the department to license an applicant as a behavior analyst or an assistant behavior analyst, that applicant must be certified by an organization, which we refer to as a certifying entity, that is approved by the department to issue credentials in the professional practice of applied behavior. Right now, there are only two certifying entities approved by the department. The first is the Behavior Analysis Certification Board, which I'll refer to as the BACB. And the second is the Qualified Applied Behavior Analysis Credentialing Board, the QABA. Both boards develop their own curriculum and educational standards for their respective certifications, and each board's certifications are recognized as satisfying the qualifications for licensure by the department. At last year's December meeting, this commission requested that, I'm sorry, not referring to 2025, but to 2024. At last year's December meeting, this commission requested that the department develop its own standards for certification. These alternative standards would exist independent of the BACB and QABA certifications and would effectively allow the department to function as a third certifying entity. In order to realize this commission's request over the course of 2025, TDLR's compliance, licensing, education, and examination, and general counsel divisions met extensively to discuss and research how the commission's request could be realized. To that end, the department developed these requirements for future organizations that desire to be recognized as a certifying entity. These guidelines were summarized in the memo we included in your meeting materials. We also have a spreadsheet that includes a side-by-side comparison of the BACBA, the QABA, and the department's proposed guidelines. Unfortunately, it wasn't in your meeting materials, but we'll be able to provide that at the conclusion of this commission meeting. So the department's proposed guidelines effectively mirror both certifying entities' existing requirements. Namely, the applicants must possess a master's degree in behavioral analysis or a related field with 270 hours of semester hours broken down into required coursework categories. I think one of the big takeaways from the educational guidelines we've developed is the 270 hours focus now is placed more on autism spectrum disorders. This was the focus of the QABA's own educational guidelines. And due to the increasing, prevalence of spectrum diagnoses, autism spectrum diagnoses in Texas and nationally, the educational guidelines that we've developed place really the bulk of the 270 hours required for a certifying entity on the autism spectrum disorders. Like the BACB and QABA, the proposed guidelines provide that any future certifying entity must require at least 2,000 hours of supervised independent fieldwork and ensure sufficient procedures are in place to verify those hours are properly accrued. I believe this was a concern of Dr. Callis's back in our December commission meeting. He was concerned about the 1,500 hours that was at that point the QABA's supervised independent fieldwork hours. So again, I want to emphasize here is what we're recommending is the floor. If a certifying entity wants to come in and say, if you want a certification from us, we need 300 hours, we need 2,500 hours of supervised independent fieldwork, we'll be fine with that. But this is the absolute minimum for any certifying entity that would request department approval from here on out if these rules are in place. Also, you'll see in the examination areas of knowledge, the proposed guidelines require future certifying entities to emphasize testing in autism spectrum disorders and behavior reduction interventions. Again, this is due to the focus that we've decided is probably in the best interest of Texans to make sure that autism spectrum disorders are properly treated. Finally, the proposed guidelines place a strict prohibition on conditioning certification or certification renewal on the completion of DEI-related coursework or continuing education. We appreciate the Commission's interest in this issue and are happy to hear your feedback on this proposal. Once you've approved these guidelines, the Office of General Counsel will begin to process to incorporate into the program rules. I'm happy to answer any questions you might have. I'm also assisted by Anna Clark and Tedrick Woods, specialists with our Compliance Division's Health and Wellness team, whose training and expertise were essential to the development of these educational standards.
Any questions?
Commissioner High,
Yes.
do you currently do the BACB and QABA both meet the guidelines you're proposing?
That's an excellent question. We took into account there is a difference in the educational requirements, specifically in the required coursework between the BACBA and the QABA. The BACB, requires 315 semester 20 credit hours. The QABA requires 270. All of the educational guidelines that we're proposing, if the QABA came to us and applied to be a certifying entity now, they would meet these guidelines. So we've asked for 270 semester hours for the required coursework breakdown. This mirrors the QABA's standard.
And when you referred to the autism spectrum part of
Yes.
those requirements, what is the percentage of the education requirements?
So the BACB, while it has 315 hours let's call it 21 credit hours, semester credit hours for to apply for certification. None of those individual credit hour categories are specifically designated for autism spectrum disorders. The QABA has 270 or 18 credit hours. 20 of those 270 is for autism spectrum disorders. In the standards that we're proposing this commission today, 55 of the 270 hours will be dedicated to autism spectrum disorders.
And so would the BACB have to change their
No,
author it in?
we're going to, yes, exactly.
Okay. All right. Thank you.
Thank you.
Chair.
Yes, sir.
I have several questions on this one. Council Funderburk, if I recall, the reason I think Commissioner Butler kind of made this one, we heard that the BAs, behavior analysts, the shortage and the time frame to get to 6 to 9 months or something to see anyone right there.
Yes.
And my recollection of the request to the agency staff was that we got to have a tier system. I think I understand in Louisiana, it may be a lot, the threshold is not 2,000 or whatever it is. I thought that we're coming up a 3-phase approach right there. We'll have an initial ones, maybe a trainee or something. If someone wants to go see after 500 or 270 or whatever the hours it is. And the second one is something called a regular guy who can see like, like a regular doctor or something like, and then a super specialty right there, what it is. But I thought that was approach we are taking to get more people be on the process right there so that the Texans can go and see to take care of their needs right there. But I'm quite surprised at looking at this. It's a complete different from what I think I understood. Maybe Commissioner Butler can further go with that, his approach right there. And also this 2,000 hours or something, one has 1,500, other has 2,000 or something. I think that's a rat race. I thought we we're going to be independent of all of it. So I want to hear what Commissioner Butler's plan was back then when he kind of made a request.
Sure. If I may, Chairman.
Yeah.
As I recall, we talked about there's a little trepidation in the beginning because of the mandates of the DEI mandates and the things that were being compelled upon the behavioral analyst. And we've done this in the past with massage therapists where this agency just said, we're not going to let others dictate any longer what we're doing because they've gone a step too far. And that was the genesis of it. And I think we had some great discussion there because even Dr. Callis at that time, there were some great analogies made when somebody comes to a GP and they determine, right, they do their triage and assess do they need a specialist of some sort? And then they go to that specialist. And so I think what we talked about, if memory fails, if memory serves me right, and I'm 57 now, so it probably doesn't. But, there's a backlog for these autistic children to be seen. And so we were thinking at that time, the faster we can get them into some treatment, and some of them may not need the master's level of treatment or the PhD level treatment. Those are for maybe the extreme cases, but the faster they can get seen, maybe they can diminish some of the bad behavior, or I shouldn't say bad, the unwanted behavior, or whatever the appropriate term is. Forgive me for the inartful lexicon that I'm using because I don't know how they address this. But, maybe like at the bachelor's level, if they're overseen by a master's or a PhD, that they can handle the less severe cases just to get them in the system so that, unwanted behaviors don't solidify. And I think that's what the discussion was, if I'm remembering correctly, so that anybody can get treatment soon and not wait 6 months, right? Because families are desperate to get their children seen and some of these behaviors addressed. So I think that's what you're talking about, Commissioner Droxaram. And so I think that's it. Let's make it available as fast as possible. And that's what the tiered approach, I think, was.
Dr. Wesson, I know you were on this too.
Yeah, I know. This is going back on some. And council, have y'all checked? Because I know QABA has been working, and I forget when their active date was, but they've increased the hours in their program because we've already had this discussion back in the summit deal, and we went ahead and approved them. So they're just working with aligning that a little bit better. And also, I wanted a clarification. I didn't hear real well on what was the end part about the DEI deal, because I'm under the impression that the state of Texas has kind of pulled a lot of that out of coming into play.
So, Dr. Wesson, to your first point, you're correct. The QABA used to be 1,500 hours of supervision for certification. That's been increased to 2,000 hours. Initially, the BACB did require DEI elements throughout their coursework curriculum, but this, I think, they understood the general tenor of political motivations at this time and pulled back DEI. So there's no longer a requirement for a CE. The QABA has no DEI requirement, and neither does the proposed educational guidelines. I'm not sure if that answers Commissioner
No,
Butler's
that
question.
answers it well, and I think this is a continual step, you know, for Texas to be able to keep progressing on helping these kids, because it's quite a challenge, and quite honestly, some of the GPs or PCPs they don't ever identify it, and so this has given us more options for people to get there. So thank you for all your work on doing this, and I think it's a good part.
And one, just as a commission, one aspect that I think I kind of glossed over is that these educational guidelines, they're for behavior analysis, which is like the primary practitioner in a behavioral analysis. For a behavioral analysis, there's also a assistant behavior analysis, which is a lower set of standards or requirement. Generally, it's what people get initially as they work towards. So the educational guidelines that we would be proposing would also include a set of standards for certification as an assistant behavioral analysis, which would be a lower tier and hopefully get more boots on the ground.
Great. Thank you, Mr. Chairman.
I just want to let the agency know how proud I am of y'all. You've taken something and just from scratch and built a program around it, right? Massage therapist was easy compared to this. You know, what we did when we pulled the plug on this sent shockwaves through the nation. So whether it's the FCIC or this program, Texas leads the way. In many ways, we are that shining star that's on our flag. Sometimes we're the lone star. We're going about it our own way, and that's okay because we're doing it right. So thank you for what you've done. You are a standard setter. You really are. And they're going to name this the Funderburg procedure or principle or method or.
All right, let's pull that back a little bit. All right.
Yeah.
I'll make a motion. I'll make a motion.
Is there a quick comment?
Yes,
Go ahead.
sir. I think, council, if we are trying to do a program ourselves, state law pretty much prohibits us from doing anything on the DEI right there.
Yes.
That's pretty much laid out.
Yes.
And what's the rationale of we trying to put the DEI in the documentation that I understand we don't need it,
Yeah.
but I think, you know, it complies with the state law. That my take is I don't want to see anything.
Right.
That's one comment. And the second one is you mentioned about the assistant or something, but I didn't see in the documentation the assistant or whatever it is. Is there other document which I'm missing?
We'll go. Part of that was in the Excel spreadsheet that we developed, but no, we will have that at the end of this commission. At the end of this agenda item, what I'll be proposing is that this the commission. Let me get my script. Would ask the commission to make a motion authorizing a rulemaking to add these recommendations governing educational guidelines for certifying entities into the administrative rule. And at that point, what we would do is develop these recommendations into administrative rule for both behavioral analysis and for assistant behavioral analysis.
Chair, I would like to table this one till I see that paperwork.
No, certainly we can get that for you.
Is there a second to that?
Just one more question. Isn't there a technician as well on the
There-
level?
There is a behavioral analysis technician. However, those are not regulated by the department.
The assistants, okay. You guys, a motion, there's a second?
To table?
Yeah. I know, you got, is there a second?
The Excel spreadsheet?
Could you get us that sheet before the end of the meeting? Maybe
I
that we
think
could-
so, yeah.
Can we push this just?
And if I could,
Okay, we hang on, gentlemen. We got a motion. Is there a second? Okay, it dies of a second. Is there comments you want to make?
Were you about to say something?
Vice Chair, yes, I was. Courtney Arbor, Executive Director. I wanted to let you know that in that material that they'll be sharing are the license types that we have regulatory authority by law. There was some talk about an entry level license of some sort beyond what we do regulate. That would require statutory change. So this is a good discussion for us to continue having. If there's yet another level that you'd like us to approach the legislature about working with industry, we can do that. But what you'll see only reflects the framework around the certifying entities for the licenses that we regulate.
As much as I
I-
hate to admit it, I think Commissioner Draksharam is right. We should probably see this. It just by happenstance, it wasn't included in the packet, correct?
Yes.
It's just a simple mistake, but we probably should see it before we vote on it. That's a reasonable thing. That's not an
So,
unreasonable thing.
okay. Are you going to make a motion to table again?
Yes, I guess I hate to do it because he's
You got
right.
I don't, I got you.
I don't want to
We'll
validate
make a
that.
motion to table again. All
Yes, sir.
Is
I'd
there-
like to
is-
make a
Is there a
motion to table
second? Okay, we have a motion second. All in favor, say aye.
Aye.
All opposed?
No.
No. Okay. The ayes have it. The motion's been tabled, and we'll look at it. from
We'll
there.
get through
Okay.
that information. Thank you, Commissioners.
Thank you so much. Appreciate you.
Okay. Make sure, Mr. Penderberg, I want this to be settled. Give these commissioners what they want, and I want to make sure Doug, this gets on that item. All right, this is a tactical. I don't want this we need to address this issue.
Gotcha.
So I want this done by March. And all right.
Yes.
Got
Thank
it.
you, Commissioner.
Good.
And
I'm
Chairman,
sorry,
Can
Dr.
I
Weston.
make one last comment?
You're killing me, but go ahead, Dr. Weston. Go ahead.
No, I just think from what Executive Director mentioned, we're basing where we're at now on what the legislature has passed, and we brought it up to a higher level than what Texas had before. And having an autistic grandchild in my family, we're just keep trying to reinvent this, and we're going to reach a point where we're going to have to say, okay, the legislature has to go back and do this, and then we're another year or 2 years down the road. I think this is a good start. I said this is a step, that gets some of the educational part, and I'm disappointed in the fact that we couldn't understand that.
I agree. Okay. All right. Well, it's done. March. I want to see this on there. Okay. Thank
We
you.
will have that all information for you. Thank you,
There
Commissioner.
shouldn't be an excuse for it. All right, let's go to the next item. Item M. Good morning.
Good morning, Commissioners. For the record, I'm LaDonna Castanuela, Director, Charitable Bingo Operations Division. Item M is a bingo advisory opinion, and it is your first since we've been at this department. On November 12th, 2025, Cesar Biggity, on behalf of Tabs of Texas LLC, a licensed distributor of bingo pull tabs, requested this bingo advisory opinion. He asked several questions about a scenario involving a building owner who leases a bingo hall to one or more licensed authorized organizations to conduct bingo. He specifies that the building does not hold a lessor license and is not listed on the bingo worker registry, and that the bingo games at the premises are conducted by registered bingo workers who are associated with licensed organizations or charities. Specifically, Mr. Beatty asks whether any operational direction from the unlicensed owner to registered workers is prohibited as an exercise of operational control, whether an unlicensed owner may instruct bingo managers as to which pull tabs to purchase, which games to play, or make any operational or purchasing decisions related to bingo sessions or pull tab activities. He asks about potential violations or enforcement consequences if an unlicensed building owner directs or controls the conduct of bingo, and what actions the organizations should take if such interference occurs. He also asks, what are the consequences if the licensed operator or registered bingo worker follows instructions from someone who does not possess a valid worker registry or lessor license, and would it constitute a violation by the operator or the licensed organization for allowing unlicensed influence or control over bingo operations? The proposed bingo advisory opinion in your materials explains a person or an entity that leases premises on which bingo is conducted directly to one or more licensed authorized organizations is required to hold a lessor license. However, a non-licensed building owner is not prohibited from leasing premises to a licensed lessor, who then leases the premises to the licensed authorized organizations for the conduct of bingo. Further, at the time of licensure or renewal, an applicant or licensed bingo conductor must submit the address of the premises, where, and the day and time when they intend to conduct bingo under the license, and the name and address of the licensed commercial lessor. All of this is to say that the situation described by Mr. Beatty should not arise. The advisory opinion also explains that all licensed or authorized organizations designate a bingo chairperson who will be responsible for overseeing the bingo activities, a bingo operator who must be present during the bingo occasions and whose name is posted. Also, the bingo manager oversees the day-to-day operations of the bingo premises. All of these persons must be listed on the registry of approved bingo workers. Registered bingo workers and bingo licensees must always follow the law and rules. Failure to do so may result in administrative sanctions. Mr. Beatty asks whether the unlicensed building owner may give orders, directions, or instructions to the registered bingo workers about the conduct of and the operation of bingo, but does not describe or explain whether the operator, manager, conductor, or other registered workers have to follow or are following such orders, or whether those orders, if followed, would violate the BEA or rules. The interaction between an unlicensed property owner and the bingo worker staff is not contemplated nor addressed in the Bingo Enabling Act or the rules. Again, all bingo licensees must adhere to the Bingo Enabling Act and the bingo administrative rules, regardless of who gives them orders, directions, or instructions. Finally, the advisory opinion invites Mr. Beatty to submit a complaint in writing to the department's online complaint portal if he believes the violation has or is occurring. As Ms. Rains just said in the cover memo for this item, staff recommends approval of the proposed bingo advisory opinion and delegation to me to sign it and issue it to Mr. Beatty. Once issued, the advisory opinion will also be posted on the department's website, and an emailed notice with a link to the advisory opinion will be sent to all industry representatives in our licensing database.
Thank you. Any questions?
Yes, Chair. Has this been sent to the advisory or the board, bingo advisory board?
No,
Are they-
sir.
Okay, the time constraints assume, correct?
It's actually not part of the process. So the proposed bingo advisory opinions have not in the past been run by the bingo advisory committee. This is the commission's advisory opinion.
Okay. Any other commission questions? All right, I'll take a motion.
Chair, I move to, on the, the bingo advisory opinion number 2026-1112-0001, approve the response and delegate the charitable bingo operations director to sign and issue the response to the requester.
Is there a second? All right. All in favor, say aye.
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 All those opposed? All right, motion carries. Thank you. Item N.
I'm gonna have to drop off.
Okay, thank you, Dr. Quest. Appreciate you.
Good seeing you, Gary.
Take care.
Yes, sir.
Good morning. Sergio Rey, Interim Deputy Executive Director for the Lottery and Bingo Operations. According to Texas Occupations Code 2001-57, the Bingo Advisory or Committee, or BAC, is appointed by the Commission for the purposes to advise the Commission and the Department on the needs and problems of the state's bingo industry, to provide input on rules involving bingo during their development and before adoption, to report regularly to the Commission and the Department of the Committee's activities, briefing the Commission and the Department on advancement and challenges of the state's bingo industry, and to perform other duties as determined by the Commission or the Department. As such, by rule, the Texas Administrative Code 141-102, the BAC will have a work plan containing items that the Commission determines, and that the BAC may submit items for the work plan that are relevant to the state of the bingo industry. In the same rule, it states that the BAC will report to the Commission on its activities relating to the commission-approved work plan at the commission's final meeting of the fiscal year. In August 2005, Mr. William Trace Smith, the chair of the BAC, submitted the BAC's proposed fiscal year 26 work plan items. Those items are incorporated with minimal edits into the work plan presented to you for your consideration today. The proposed work plan in your materials was reviewed by Charitable Bingo Operations Division, including LaDonna Castanuela and I. It addresses all items mentioned in the statute and the rule, including those regarding industry needs and challenges, and rule input, and some additional items aimed at helping staff address sunset recommendations related to paper reduction and database updates. After our review, it was augmented to emphasize the role industry plays to identify methods and opportunities to raise awareness of the role and contributions of Charitable Bingo makes to Texas, as well as updates to the BAC's annual report development requirements and deadlines to align with the scheduled commission meetings. We are requesting approval of the Bingo Advisory Committee fiscal year 2026 annual work plan. This completes my remarks. LaDonna and I are available for questions.
Thank you. Any questions?
No, sir.
Okay. I'll take a motion.
So move to approve the Bingo Advisory Committee's FY 2026 annual work plan.
Is there a second? All in favor, say aye.
Aye.
Opposed? All right, motion carries. Thank you.
Thank you so much for all your work.
I'm going to skip to item P, commissioners, on the appointments, just because it's our last voting item, and I want to make sure we get that before you. I know we have one more left, and we're losing commissioners.
Yeah.
So, if you don't mind, Suzanne.
Good morning, Chairman, Commissioners. Susanna Holt-Catrone, Chief of Staff. This morning, we are recommending 4 appointments for 3 different boards and/or committees for your consideration and approval. And if you're amenable to me introducing all 4 appointments for your consideration and potential motion, I'll proceed just in one.
Sure. Be great. Thank you.
All right. For the code enforcement officers, we have 2 applicants. Stacy Graves of Cedar Hill is recommended for the advisory board to fill the seat of a registered code enforcement officer. Ms. Graves is currently the Development Services Director for the city of Cedar Hill. She has more than 28 years of code enforcement experience, and this would be for a term expiring February 1st of 2027. And Darren Raskin of Montgomery is also recommended for the board to fill the seat of structural engineer. Mr. Raskin is the Deputy Director of Building and Safety for Wildon, a company providing engineering services to municipalities. He has more than 30 years of experience in structural engineering, and this term would expire January 27th, 2032. Jared Nichols of Irving is recommended for the Electrical Safety and Licensing Advisory Board to fill the seat of a public member who is a building contractor principally engaged in home construction and is a member of a statewide building trade association. Mr. Nichols was formerly the president of Amber Electrical and now serves the leadership team of the company as their senior advisor. He has more than 47 years of experience in the electrical industry, beginning his career as an electrician and eventually owner and president of the company. He is a member of the Independent Electrical Contractors Association, among others, satisfying the requirements of his seat. This term would expire January 27th, 2032. And finally, we're bringing before you today the 3rd of 9 positions for the Lottery Advisory Committee. David Pate of Rowlett is recommended to fill the seat of beneficiary, referring to the lottery's funding benefit to veterans and public education.
Mr. Pate is currently the Assistant Superintendent of Finance and Support Service for the Richardson Independent School District. He is a certified public accountant. Prior to his 28-year career in finance with both Richardson and Garland ISDs, he previously worked as an auditor in the private sector for more than a decade with a focus on state and local governments.
Any questions, commissioners?
Yes, Chair. Want to commend Ms. Coltrone for the remarkable job on the advisory committee appointments right there. What a transition right there. Now I do see the conflict of interest where each of the members have signed that they don't have any conflicts. Thank you for your leadership on this one to put the whole package and everything up in the explanation. On the advisory committee, I don't see a term expiration. Is there a reason?
There's currently no term set for the members of the Lottery Advisory Committee. Like the Bingo Committee, once the committee is complete, General Counsel will bring forward recommendations for staggered terms in accordance with the statute.
Commissioners, this is a very specific positions, and so your help would be warranted on this. And you can give us Sienna on this, but we only have 3, as you mentioned, of the 9.
Yes, sir.
So we need to. So any contacts, any efforts would be great. Any further questions?
Yes, sir. Chair, I think, this is again an issue what I was looking through the meeting minutes. Here we appoint them, okay? Which is today, the February 18th. We come back in March 24th or something. That's where we ratify our meeting minutes. Okay, this is Part A approval right there. And Part B is the ratification of our meeting minutes right there. That's primarily where we get, technically, that's the time all these appointments are effective. So I looked at all the stuff. I think, some of them are needed. I don't know, General Counsel, what do you think if we can put on this one that the appointments are effective today? Is that something
I
makes
assume
sense?
that they're effective when we approve it. Is that accurate, Doug?
Yes, for appointments, they're going to be effective the date of approval. So
Not for
today.
minutes approval.
Right, correct.
Okay.
But what happens during the, Chair, if you may,
Yeah.
if I may, what happens under Robert's rule? If I'm in the majority, I can always bring it back to table or whatever it is with the majority of whatever information we have. Because technically you can do it. That's what I understood.
I'm sorry,
the
I'm not,
meeting
I'm not
minutes.
understanding the question. My apologies.
So the question here is, when we make an appointment today, which is basically Part A, because Part B is a meeting minutes, which basically says that we have taken a decision right there. How does the general public know? The public know based on the meeting minutes, not necessarily they're going to be watching us on TV or whatever it is. The meeting minutes ratify the position what we have taken.
I think the fact that we make this, the fact that we make this meeting publicly available and viewable and and recorded on YouTube is part of the way that we inform the public of what the commission is doing. I also agree that the minutes serve an important part of recording the decisions, but they do not override the decisions that you make in the meeting. And so, even if there were to be some sort of incomplete statement in the minutes, because it's, again, like you mentioned, we've got to get these appointees on the board first before we can figure out the staggering, and that's just because it's a new board, and we need your input. The fact that we don't have a complete record of all appointments to the board that doesn't keep these decisions from being effective. I'm struggling a little bit.
We'll note your concern, Commissioner, but I think as long as I'm clear that once we vote, it's certified and we're done. So, but if the concern, we want it documented in the minutes of his ideas that the ratification might not occur until the minutes approval of the next meeting. I don't know if that's accurate or not, but we'll follow up for you on that. Is that accurate?
Would you be open if I make it effective today, the date?
You're welcome to make the motion to make it effective. Absolutely. Please do.
Okay, so I move to, what is that? All the recommendations for the advisory committee effective today, February 18, 2026.
Okay. Is there a second?
I'll second that.
All right. All in favor, say aye.
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 All opposed? Motion carries. Thank you. And not to dismiss your point, Doug, we'll just make sure that if that point of clarification needs to be done parliamentary procedures. Let's get that done. In that vein, did you find out about the minutes?
I did, Chairman. They are correct.
They're correct.
Yes,
There's
sir.
no mod, good. Okay, all right. Thank you. So I can take a motion on those minutes?
I'll make a motion that we adopt the minutes.
There's a second? All in favor, say aye.
Aye.
Aye. Opposed? Okay, noted. Commissioner Dockstrom, opposed. Okay, motion carries. Thank you. All right, we now go to work groups. Item O. Yes.
I'm happy to introduce them. Courtney Arbor. There are a number of work group updates today. I believe Vice Chair Butler will be providing the anti-human trafficking work group update.
Yes, ma'am. Mr. Chair, are you ready for that?
Yes, sir. Thank you, sir.
Okay. Ms. Cotrone, I just wanted to say the caliber of people that you're bringing to the advisory board is tremendous. Thank you for the work, and everybody that had a hand in it. Please let them know how much we appreciate that. Thank you, Mr. Chair. Sorry.
Absolutely. No, thank you.
The Anti-Human Trafficking Commission Work Group. The Anti-Human Trafficking Commission Work Group met on February 11th, 2026. There are 3 points I'd like to make, and that is that staff provided an overview of new procedures and that were implemented to investigate and inspect massage schools suspected of fraud or misrepresentation. Since implementation of those new procedures, 3 massage schools have been closed. Congratulations. Thank you. Thank you. That's the spigot from which human trafficking starts. So we're cutting off the spigot. Thank you. The Anti-Human Trafficking and Education and Examination divisions are working together to respond to students affected by the closures and make determinations about their accumulated instruction hours and eligibility for licensure. The last one is the agency's collaborative efforts to train and support local law enforcement and code enforcement officers were very successful with the City of Midland and in Williamson County, and additional community impact projects are underway. We'll bring those to you as they develop. Mr. Chair, that's it for the Anti-Human Trafficking Commission work groups.
Won't you go ahead and go to the audit and finance?
Yes,
please?
sir. Thank you. And please let everybody in the Human Trafficking Division know that we appreciate the work that they're doing. We know the impact that they're having on lives, and thank you for that. The Audit and Finance Commission Work Group. The Audit and Finance Commission Work Group met on Friday, January 16th, and staff presented new audit tracking tools and dashboards. As you can well imagine, with the lottery and the bingo, it is probably more than doubled. I would say the number of audits that we have. So the work that they are doing is yeah, I would hate to do it. It's gotten so expansive now that they have to have this Excel spreadsheet to keep track of everything that's going on. And discussing what is included and how information is obtained and presented within the tools that they've implemented. TDLR policy research and fiscal analysts have developed an audit tracking tool consisting of spreadsheets used to track progress of various licensing and regulation and lottery and charitable bingo related audits. The analysts have begun quarterly check-ins with staff responsible for implementation of the audit recommendations and opportunities for improvement. Write-ups and dashboards are provided to executive staff and audit finance work groups. The executive director, chief financial officer, and analysts will meet quarterly with the audit finance work group to provide updates on the status and various audit findings and opportunities for improvement. I'm sure there are going to be various things that need tweaking and changing, but we're embarking on this for the first time. So thank you for all that you've done. Thank you for all that you're going to continue to do. And I look forward to seeing what continuous improvement looks like in this world, because just developing the tools is yeoman's work. So thank you for that. Please let everybody know how much we appreciate the work that they're doing. They don't see it because they're not members of the work group, but it's a tremendous amount of work. So thank you to everybody involved in this. The agency has done a tremendous job of bringing in lottery, bingo, and scratch-offs. And I can't tell you how proud I am of you. It's impressive. Thank you.
Thank you, Commissioner Butler, for leading that. We're going to enforcement. Do you have any?
Consists of Chair Commissioner Wesson, members Commissioner Butler, and Commissioner Dockstrom. The enforcement work group met on January 6, 2026 to discuss the status of process improvements in the enforcement division. As you know, there's a huge backlog, and I think a lot of stuff has been planned to get to the core. And I got to commend Mr. Bruno for doing what got to be done right there, identifying what are the old cases and all. The division has broadened the types of cases that legal assistants can handle without attorney review and increased the number of legal assistants that may work on those cases. The division has updated its procedures to allow the investigation managers to close cases under certain circumstances. That's all the report I have.
Great, thank you. Thank you for staying on top of that, Commissioner Dockstrom. All right, HR Commission, I chair that. The HR Commission work group met on January 29th to discuss the upcoming performance review of the executive director, including the instrument that we used in the timeline for drafting. Seeking commissioners' input and administration is in May 26th. So that'll be coming on with HR. And then Innovation Commission. Is that you?
Actually, Commissioner Wesson and I and Commissioner Castaneda are on this innovation work group. The work group met on January 29th of this year to discuss the status of the core project. And the staff provided updates on implementation timeline, team member changes, and elements of the project under review. The first wave is scheduled to be released in February. And I was impressed by the progress and the process because there's not a fear of backtracking if necessary. If there's no fear in reassessing just to make sure things are right. So thank you for everyone on the in the innovation process.
All right, I think you got the midwives.
Yeah. So the Midwives Commission group is composed of Commissioner Callis as chair and Commissioners Butler and High. We met on January 7th of this year. Staff provided an overview of the procedures that the Enforcement Division has in place to review complaints relating to midwives. The work group reviewed program rules in place pertaining to medications that midwives may administer under a physician's delegation. Further discussion is planned to review scope of practice for lay midwives and agency resources to address pending complaints. But I think everyone is in agreement that we all want safe practice, and is doing a great job of just being informed and providing communication between them and the midwife group. So that's all I have on that one.
Commissioners, thank you. This is new. We've been pushing this, but you guys are doing a lot of work to create the efficiency of this commission meeting when it comes out. The work needs to be done. So thank you your efforts on that. This is discovering a lot of opportunities for growth. And so as this thing gets bigger, these work groups are going to be more pivotal. So thank you guys for doing that.
I do have a couple of updates, and while I start mine, Sergio, Steve, and Suzanne, if you want to make your way to the table, mine will be pretty brief. I just want to provide a quick update on our transition, or what we're now calling the integration of lottery and charitable bingo to TDLR. We have a great mix of staff in this room, and you probably don't even know in some cases which side of the agency they were on a few months ago. In some cases, we're sitting by each other, and the integration is going very well in a number of ways. I wanted to let you know that we've started the heavy work on the RFP. So we're in the quiet phase for the RFP of the lottery operations system. And Nicole Oria, who was hired as the special counsel, has recently moved on to HHSC, where she's taken a permanent job in contracts and procurement. So we really hated to see Nicole leave, but the responsibility for project managing that procurement now lies with Rose Wheeler-Demerson, who recently joined our agency and has a lot of great experience on procurement and contract. And we have every bit of confidence that the procurement is going to go very well with Rose and her team, and Glenn Neal continuing to help with the procurement. When it comes to integration of policies, we've taken what we're calling the best of each approach. We've looked at how the lottery or bingo side was managing a process and look at the formerly known as TDLR, now we call it licensing and regulation side, and to see what was best, and should it be a hybrid of the two policies or procedures? Should we adopt one versus the other? And each department is looking at policies in that light, which is proving to make us a better agency because we are truly taking the best of each side of the agency. At the beginning of the year, HR looked at our processes around skeleton holidays and how we would handle those things. They also, HR also provided training on a more streamlined and efficient hiring process, which is still evolving because we recently had some news that you can accept, as a state agency, you can now accept a resume in lieu of a state of Texas application, but they're continuing to adapt and make sure that everyone, every hiring manager understands the new process. General Counsel has provided structure to the open meetings posting process and the way we manage internally the preparation for those meetings, which you're probably noticing. And the administration team, including facilities and procurement, are cross-training, identifying efficiencies and working well together. So these are just a few of the examples of where we're still digging in to change all of the legacy processes and procedures to now fit a much larger agency. I'm really proud of the staff for being able to look at both sides or both existing policies and find what works best for us moving forward. And I'll turn it over to Susanna for the next update.
Commissioners, I wanted to provide some additional recognition and thanks to staff who are working in the anti-human trafficking space. Commissioner Butler referenced the closure of the suspected diploma mills during his report from the work group. And I wanted to share with you all that there's a dedicated team to providing support to any students of these entities that want to further their education in a legitimate school. To date, there have been the 3 school closures. Staff from education and examination, anti-human trafficking, have sent letters to just under 900 students to address their record and invite them to provide their transcripts for guidance on transfers to other licensed massage therapy schools. Approximately 17% have responded to date. So I wanted to thank the staff who are providing communication and outreach and review of the transcripts in accordance with the education requirements in the industry, and providing support for the students should they choose to continue their education at a credible school. In addition to the focus on diploma mills, the Anti-Human Trafficking Division has issued 36 NOAVs for sexually oriented businesses this fiscal year. They have issued 19 emergency orders, immediately shutting down locations suspected of operating illicit businesses. And I really want to applaud not only the team led by Elizabeth Wiggins, but also the professionals working in education and examination, the field inspectors, the investigators, the legal assistants, and the prosecutors in enforcement who are contributing to the dedicated work. Also, HR has provided support to anti-human trafficking. They currently have 15 of their 20 positions filled. And a recent development this month is that Songhee Dobson has left the agency, but she continues her fight against human trafficking. She's gone to work for BCFS Health and Human Services as the Director of Building Bridges Against Trafficking program. Songhee joined the agency in June of 2023. She joined us from Refugee Services of Texas, where she worked closely with survivors of trafficking. During her time with TDLR, she played an important role in developing and strengthening our victim assistance coordination in response to illicit massage. We wish her well in her new endeavor, and with the goodbye came some hellos. Anti-human trafficking will onboard a new attorney in March, and in January they welcomed Robin Finney, Deborah Hicks, and Stacy Wickopan, who transferred to the AHT division as investigators. And also this month in February, Cindy Fletcher joined the legal assistant team. So thanks to all again for devoting their time and talents to this effort.
Thank you, sir. Sergio?
Again, Sergio Rey. This week, we're excited to process a Loteria Supreme $7.5 million winner. This was a $100 scratch ticket winner that was sold in Robinson, Texas. We are still pending the processing of the same $78 million Lotto Texas winner from this past November. The attorneys of the potential claimant have contacted our offices, but no, we have not continued through the whole claim process yet. The winner has until mid-May to claim this prize. Through the end of January, the lottery program has collected sales revenue of $3.39 billion. This is slightly lower than this time last year at $3.45 billion, roughly about down 1.6%. Even under these results, the Foundation School Fund has received $678 million. That's $9 million more than this time last year. The Texas Veterans Commission has received $13.3 million through January. This is approximately $500,000 less than last year. And as we continue to see the increases in the drawing jackpots and bring to market scratch tickets, which appeal to our Texan customers, we expect to maintain steady sales, to match and hopefully surpass those sales and revenue from last year. I also would like to take an opportunity to, kind of in the spirit of the show must go on. At the end of January, we had a very impactful ice storm, but our Draw Studio staff were here at our Draw Studios to make sure that our drawings for Saturday, Monday, Tuesday still went on time. In the 30-plus history of the Texas Lottery program, we have not missed one drawing. So kudos to the staff, and I totally appreciate their commitment to this program.
Congratulations. Mr. Bruno.
Thank you, Mr. Chairman. Steve Bruno, Deputy Executive Director for Licensing and Regulatory Services. I wanted to provide just a little bit more from Commissioner Hai's update on the core licensing system. That is the focus of a great deal of work right now. If you've ever built a house from scratch, you know that you lay out plans and then you get out there and you start working and they change. And Commissioner, I want to thank you for recognizing that nimbleness that you mentioned. We are working together with our vendor CGI to develop the best system that we can for us internally and externally. And one addition I wanted to make to that update was that we recently brought on the independent validation and verification services. You all voted for that in your previous meeting, and that's an excellent tool designed to help us ensure that we are getting what we need. This is, as you know, a very long-term project and a very important one. It's, as I said recently, it's probably the most important project that I will have the privilege to work on in my career in public service. And while that's going on, I just want to acknowledge the work of all of the folks on the 6 divisions that I'm privileged to work with: licensing, customer service, education and examination, compliance, field inspections, and enforcement. While all of this work is going on for the core system, the regular work continues. And staff are keeping up with the paces that they've set, keeping up with the new license types that have come on since last session and all the other changes. And so that is something that I want to publicly thank everyone for, because when you work on a 3-year project, and as we're getting into it, the amount of time and the amount of resources that takes to pull this off correctly is really incredible. And to be able to balance that while also continuing our regular work is commendable. And I wanted to make sure that you all knew that and that our staff heard that as well. Thank you.
Bruno, appreciate you. Courtney, is there anything else?
Nothing else from me. Thank you.
Chair, can I make a comment?
Yes, sir.
I want to thank, again, typical, your license numbers show about less than 200 or something from whatever it is. Thank you. Yeah, right there. Thank you. Hopefully we'll get to the enforcement shortly. But in terms of the lottery sale, Mr. Ray, I'm going to say this one: the chair and the vice chair are the biggest buyers, and they haven't been spending the money lately.
All right. Any other comments? All right, I'll take two. I know we're going to table two motions. Doug, you got those two motions that need to be tabled, and make sure to follow up on Commissioner Dr. Rom's comment about the ratification. We want to make sure to clear that out if the minutes do the ratification or at the point, just for point of clarification. We did check on the minutes from last time. We're correct. So much thank you, guys. I know it's been a arduous process of cultures coming together for one great cause, but I cannot tell you, I know the commission is fully aware that the energy that we have is going to be so obvious as I know we get into this legislative season. We never know what they're going to do, but we have got a lot of energy in what we do, and I appreciate each and every one of you. Thank you, Courtney, for doing your job and just a great way, and thank you, Carnisa, for herding cats. Or lions, if you would. That's probably a bit more appropriate. And I appreciate you guys' time and energy in each and every one of this thing. And I love the discussion that's public. I love a discussion that's not on the same side. And it pulls us into a better, stronger place each and every time we do that and have that. So I'm excited about that.
Chair, can I make on one of the meetings in October 27th? We are moving it to North Campus. I want to see some continuity. Is there something we can move the date?
Great question. Courtney, would you like to address that?
We're watching this room closely through the year to see if that day frees up. We needed a meeting at that point in time and knew that you'd want to meet in the month of October. So our hope is that this room will be freed up and to keep our dates consistent through the year. Worst case scenario is that we keep the schedule and move it to North Campus, but we agree that's not ideal. If we do have to move it, we'll be very thoughtful about how we get that information out to the public and overkill that communication so people know where to attend the meeting.
Thank you.
All right. And so but I think the adjustments to this is the first time we've met here. And it's new, and anything new is kind of uncertain. So I would tell you that we'll figure this out, and we appreciate the technical difficulties, but going through that with the staff, we appreciate that. Commissioner Butler or Vice Chair Butler.
I had a profound thought, Mr. Chair.
I'm cautiously pessimistic, but we'll go with it. Go ahead.
So why? I don't know where the 79 million is. Why do chicken coops have two doors?
Yes, Commissioner, go ahead.
Because if they had four doors, they would be chicken sedans.
Yeah, y'all want your 15 seconds of life back, and you're free to give that commissioner a hard time about that. All right, I'll take a motion for adjournment. Second. All in favor, say aye.
Aye.
All right, motion adjourned. Carried.
Thank you.
Really? That's your dad joke of the day?